Welcome to our series on writing a winning contract essay. It is brought to you by LA Law Institute, home of free educational resources. Welcome back to our series on contract law and how to write a winning essay. In our first video, we covered the first of 5 steps, which is the formation of a contract. The 5 steps are formation, changes, performance, breach and remedies. In this video, which is step 2, we will cover changes that may occur after a contract has been formed. At the end of this series, we will put it all together and show you how we followed these same steps and scored an 80 on an actual contracts exam. As we continue down our path, don't forget that these are common law rules based on the governing law we chose during formation. Step 2 is where we handle all the changes that may occur after we formed a valid contract. In real life, after a contract has been created, parties will need to make changes to the terms or even the parties themselves. The terms in a contract drive the actions of the parties, so if a term is ambiguous, it may need to be clarified. For example, let's say that it's a Thursday and the contract you just signed calls for a service next Friday. You assume it is a week from tomorrow while the other party contends that it's tomorrow. Who is right? What about when your contract calls for 10 hours of labor but was mistakenly typed in as 100 hours? What do? In each of these cases, the courts may rely on prior communications to determine the true intent of the parties. As long as the information available falls within the rules of parole evidence, the Court of Equity may use a remedy called reformation to correct the contract so that it accurately represents the party's intent. In the case of a mistake, a mutual mistake may make the contract voidable if it affects the intent of the parties. If the mistake is unilateral, such as in a typing in 100 instead of 10, reformation can be used to fix the mistake. Another possible change that may occur is that the parties have agreed to modify a term in the contract. Let's say that after agreeing to remove snow from his driveway, neighbor Ned tells homeowner Harry that he underestimated how long it will take and asks for another $100. Both parties agree on initial changes in their written contract to that effect. However, Harry refuses to pay Ned the extra money after the job is complete and Ned brings suit. Who wins? Harry will win because common law requires that modifications require consideration. Neighbor Ned had a pre-existing duty to clear the snow at Harry's home for the original price. When you see a modification in a common law contract, treat it like a mini contract. It must have mutual assent, consideration and a lack of defenses. Another possible change that may occur is when a party assigns their rights to another. When this occurs, the new party will have the same rights as the original party. However, personal service contracts or in jurisdictions where illegal, assignments are not allowed. For example, Painter Pete contracts with Harry to paint his home for $1,000. Unbeknownst to Harry, Painter Pete owes Shark Steve $1,000. However, to satisfy his loan with Steve, Pete assigns his right to receive the $1,000 to Steve. Steve can now compel Pete to pay him directly. Similarly, a party may choose to delegate his duties to another. In this case, the party that delegates will still remain liable for the completion of the duty. Like with an assignment, personal service contracts do not allow for delegation. An example of a delegation can be shown using Pete and Harry again. Like in the previous example, Pete and Harry contract for Pete to paint Harry's house. On the day that Pete is supposed to paint, he becomes ill and asks his son Lil Pete to do the job instead. Because painting is not a personal skill, this delegation will be allowed. If a party decides to delegate their duties, he has the option of completely removing himself from the contract. If the delegating party, the remaining party and the new party all agree to the change, then you will have an ovation. Finally, a change can occur in a contract when there is a third-party beneficiary. As long as the beneficiary's rights have not vested and the contract is valid, the contract makers can make changes including removing the beneficiary. For example, say that I wanted to sell my bike to pay Shark Steve money that I owe him. I contract with Mike's Bikes and name Steve beneficiary of the sale. Later, but before Steve knows of the contract, I decide to keep the money. Because Steve's rights have not vested, I am free to make this change. So there you have it, step 2 of writing a contract essay. In this video, we covered changes that may occur after the formation of a valid contract. The changes may be in the form of reformation to fix a contract or clarify an issue. Changes may also be in the form of condition which has the same common law rules as a contract. Additionally, an assignment of one's rights or the delegation of one's duties are other types of changes that affect the parties. If the delegation of duty removes a party from the contract and all parties agree, it would be a novation. When it comes to third parties, you can make any legal changes to the contract provided that the beneficiary's rights have not vested. If you have any questions, please leave them in the comments. We hope this helps with your studying.